All right, we're here today for two separate cases. The first case is Bridgestone versus Anderson, and it's my understanding Alison Stewart will be arguing for the appellant, and Mr. Dutton for the appellee. You may begin, Ms. Stewart.
May it please the court, counsel. My name is Alison Stewart. I'm here on behalf of Bridgestone Americas. Today, Bridgestone is requesting the reversal of the decision of the district court, and if the court finds compensable injuries, Bridgestone is asking that those benefits be awarded pursuant to Iowa Code Sections 8534M, which compensates the arm, and 8534-2N, I forgot the 2 on the first one, apologies, which compensates the shoulder. This appeal stems from a legislative change to the workers' compensation chapter in 2017, when the shoulder was added to the statutory schedule. Prior to the 2017 change, permanent shoulder injuries were compensated industrially. The distinction is that the schedule compensates based on functional impairment assigned by a physician, taken by the set number of weeks as determined by the legislature, whereas industrial compensation measures loss of earning capacity and considers a number of factors and results in a discretionary award that can range from some percentage of 500 weeks up to lifetime benefits. The purpose behind the schedule is to reduce controversies through certainty of compensation. When the legislature moved the shoulder to the schedule in 2017, they intended to reduce litigation relative to shoulder injuries in Iowa and make them more predictable for Iowa employers.
Maybe a little bit what they intended to do and talk about what they did do. Looking at this language, other than those described or referred to in paragraphs A through U, it seems to me maybe totally ambiguous. If you have a situation where the situation is covered by 2 of those paragraphs, M and N, that might be other than those described or referred to, or it might be covered as one of those described in or referred to. So given this situation where the language is ambiguous, do we decide in favor of the worker because it's workers' comp?
And I appreciate the question, and I think it is a general theme under Chapter 85 that we do want to interpret in favor of the worker, but we can't ignore the plain language, and we also can't read language in a statute in isolation. We want to consider the whole section. Actually, I provided the court a chart. I think you have one. Thank you. And I just did this simply. It helps me to visualize it this way. I thought it might help the court as well. But if you look at the beginning, the first line, it says, for all cases of permanent partial disability, compensation shall be as follows. And then they give an assignment of weeks to each body part in paragraphs A through R. Then S through U are some more unique circumstances, but we don't have to get to V because we can stop at M for the arm and N for the shoulder. And then V reminds us again, as you said, Justice Mansfield, that disability other than those described or referred to in paragraphs A through U, and it's Bridgestone's position that those body parts are addressed in paragraphs M and N, so we don't get to paragraph V.
It seems to me a lot may turn on the article used here. So in M, it's an arm. In N, it's a shoulder. What if it's both shoulders?
There's another case, I think, coming before you guys asking about this specific question. So we don't have any final case law on this particular issue, but I wanted to point the court to subparagraph T, which is the loss of both arms, both hands, both feet, both legs, both eyes, or any 2 thereof. The legislature didn't amend that paragraph, other than to renumerate it, didn't amend that paragraph in the 2017 legislative change to include both shoulders. But we have to assume that they were aware of the law that existed when they drafted this amendment, and that they knew that they had the option to add the shoulder to that paragraph. So I think a plain reading of the statute would suggest that when we have an arm, as we do here, and a shoulder, We can compensate those injuries individually, and then
2 shoulders, are we compensating them both separately?
with the plain reading of the statute as it is today.
Subsection that as changed mean that if it's not included, you're right, they did not include shoulder in subsection T. Couldn't that mean then go to V, all other cases?
Except that the language in V that says other than those described or referred to in paragraphs A through U, and I might
It's McDermott with the article.
refer you to an example of other types of injuries that are compensated this way. For example, if you have someone with 2 finger injuries, one on the, a pinky finger on the right hand, for example, and a pinky finger on the left, or even a middle finger and a pinky finger on the same hand. Those body parts are identified in paragraphs, it looks like, well, if you include the thumb, A through E. And those injuries are compensated individually routinely and have been for more than 40 years. They'll just award.
Does it address that, or does it just not ever get to the level, because it's such,
It's the Fry case. Just one second here, I've got the citation here for you, excuse me. Fry versus IBP, it's a 2002. And that was an arbitration decision. It didn't get to your level, but
before they made the changes about the shoulder, when you had 2 other scheduled injuries that were not covered in T, it was consistent across the board that they always just accumulated them that way?
so if you had a couple percentage points to the pinky finger and a couple percentage points to the index finger in another hand, they would just take those percentages by that number of weeks, and that was the permanency award.
You just mentioned, that's true about the fingers and stuff, but doesn't, there's one sentence in there that seems to not be mentioned. There is good argument that the agency's method of compensating multiple finger injuries is incorrect, referring to it's opposite of the AMA's guide. So doesn't that kind of water down your supposed support with Fry?
I understand that from the medical standpoint, but it is what the agency has done consistently. And they are required to follow the 5th edition AMA guides in another section of the statute. They're required to follow it. There's not room for discretion. But I think what would happen is if the physician said, 2% to the index finger and 3% to the pinky finger, they would have to just go with those ratings taken by those body parts, the weeks assigned.
Questions for you. One is, it seems like if you read the statute as a whole, that the maximum number of weeks of compensation an employee can receive is 500. That seems to be the outer limit for industrial disability under V, the 2 injury under subsection T. But if we use your method, the employee potentially could receive 650 weeks of compensation, potentially.
Actually, if I may, so you're correct. Paragraph T is taken by 500 weeks. Paragraph V can include permanent total disability benefits, which an individual worker could receive benefits for their lifetime if they have injuries and industrial disability factors that exceed the 500 weeks. Oh, I understand. Yes.
But if we use your method, potentially we could be looking at more than 500. So if we had bilateral shoulder injury under your method of compensation, that would be 800 weeks, correct?
The functional impairment ratings taken by 400, the shoulder functional impairment ratings usually range from 2%. I think the highest one I've seen is 22%. So they usually don't.
On which the compensation is paid would be based off 800 weeks. In a bilateral shoulder injury situation, you'd have 400 for each shoulder. Okay.
Awarded a full 400 because it's a functional impairment rating assigned by the physician, which usually ranges between 2 and 22% taken by 400 weeks. So then you'd have that set of weeks, which would be usually something less than 100, and then same for the other side.
Question. I guess as I'm reading subsection T, it seems like the legislature, when it comes to scheduled injuries, knows how to create a provision where you have injuries to multiple scheduled members or any combination of these scheduled members. And I guess the inference I have from that is because shoulders are not included in T, then you would go to V. Why is that not a fair reading?
Well, here we have one shoulder and one arm, and I don't mean to restate it over and over again, but I really think it is that simple. The arm is compensated in M, and the shoulder is compensated in N. And so
You could have an arm or a hand or a foot and a leg or an eye and a hand. And any of those combinations would fall within T, which indicates that the legislature knows how to schedule these multiple injury situations, but they didn't include shoulder. And maybe it was an oversight, and maybe they'll fix it at some point, realizing that they've now added shoulder to the list of scheduled members. But it seems like if they've told us how to calculate these multiple injuries, that's a separate kind of schedule.
from that they knew they could add the shoulder to T and opted not to, meaning that shoulders should be compensated individually, a shoulder and an arm, or a shoulder and any combination of other injury. They intended to have the shoulder,
Brief that if you look at T, the formulas are different than they would be if you didn't have T and just added them individually. Now, is that necessarily true with two arms? I see two hands or 2 feet or 2 legs.
I'm sorry, Justice. What we do when we have 2 body parts under subparagraph T is there's a conversion table in the 5th edition AMA guides where we convert that, and this gets a little murky, I think. We convert that body part into the body as a whole, and then there's a combination table in the back that shows us how to combine the ratings, and they usually go up a point or down a point depending. And so then we take that converted and combined figure by 500 weeks. So it's not just a clean addition like you might think.
That T would be a necessary provision even under your interpretation because the formula that it applies is different from just adding those 2 body parts individually.
Where we see it the most often is the bilateral carpal tunnel, and my understanding from the case law and the years I've dealt with these injuries is that if you have, a carpal tunnel injury on one hand, it doesn't affect you like having one on both hands. So that's why the legislature wanted to compensate people for the combination of the 2 instead of, and that's why I think it's significant that they left the shoulder out, because I think it means they intended not to compensate shoulders that way.
Pending that may also shed some light.
Versus Nordstrom case, if I flipped the parties, Karma versus Nordstrom, that's a shoulder and a shoulder injury. Been set for argument yet.
And the agency, at least in a series of cases, has said bilateral shoulder injury should be compensated under V. Okay.
Said about the case we're here about today too.
And about V. So in this case, the employee did not return to work, correct?
A couple of years later.
You have a different case where the employee did return to work at the same or higher wages. If V applied, wouldn't we be looking at functional impairment for both of those injuries anyway? Which is kind of where you are. If you just treated them as separate scheduled member injuries, you'd end up in the same place other than this fact pattern where the employee doesn't return to work. Is that right?
In light of the addition of body parts to the schedule, just the shoulder, and then this functional rating being all they can receive if they return back to same or greater earnings, we get to V depending on the body part, but we really only apply it if they end up, their job status changes.
Were there situations where you'd have like more than 2, so you'd have like even a T situation plus a thumb. I mean, a leg and an arm and a thumb, or, you know what I mean? So what would those kind of injuries happen when there are even more than two?
To that, if there's more than 3 body parts, you would get into V. So I'm not aware of any cases, and I could be wrong here, where you had 3 body parts and T applied. I think you'd get to V because of the 3.
Why, if it's 3, would it be different?
It's not included in the chart because it's later in the code section, but there's a portion of that section that talks about more than 3 body parts and that getting an injured worker into industrial disability. And it doesn't happen all that often because a lot of times, your injury is like your thumb and it extends into the hand, so then we rate the hand and pay based on the hand, or that it goes into the arm. It's unusual for someone to injure 3 distinct body parts in the same incident. It doesn't come up all that often.
Thank you.
I'm just about out of time here, but I would just like,
It's like it's shrinking, but your number's growing. That's okay. You get to come back, so that's all right. It's a very confusing clock. You're not the first.
thanks.
Thank you, Your Honor. May it please the court. I was going to introduce myself in reference to my law firm, but in honor of the guests here today, I'd like to say I'm Channing Dutton. I'm a 1973 graduate of Lincoln High School in Lincoln, Nebraska. We're the Lynx.
On your next round, you need to tell us too. Thank you very much. I meant to do that, and I appreciate that.
It's very appropriate, and I appreciate the court doing this for our guests here today. If I could just take the questions that this court has already asked, I would tell you that the most important case that you have already decided, Justice Oxley, you wrote it on December 23, 2023, called Tweeten versus Tweeten. And Tweeten was the work comp statute of limitations case where the worker was saying, I would like you to extend the discovery rule that we previously recognized in this state. But the court was heavily swayed by the action of the legislature in 2017. And the court basically took a position that was first enunciated in 1957 in a Supreme Court case called Young. And that is, our job is to hew the line between ourselves as a court of law and arguments about public policy. We should enforce the statutes as they are written, especially when they are plain, easily understood, and we need to bear in mind the obligation to not leave statutes redundant or irrelevant in our analysis. So in Tweeten v. Tweeten, the analysis was the Supreme Court went into Iowa Code Section 8526, the statute of limitations provision, and I'm going to say they unzipped it, then they opened it, and they went into the language of the statute, and they changed the language. And this court said, how can we ignore the legislature? Because this compensation system is a creature of statute. They are the authors. It's their lexicon. They pick the language. And Justice McDermott, you asked the question about the singular being used in Iowa Code Section 8534N, because it does say a shoulder. And this is intentional. With the handout that Bridgestone provided you, I made my own notations. I took a yellow marker and I marked the word shall in the preamble of the listed code sections. I marked the singular in subsection M, an arm. I marked the singular in subsection N, a shoulder. But then down at the bottom, it says in all other, it means all other cases, but I marked the word all, it means everything else. And again, the word shall appears. And this is Iowa Code Section 8534.
I mean, you could try. I still think it's ambiguous. It says, other than those described, why couldn't it be, those described include an item that's described in M plus an item that's described in N?
Draw special emphasis to this court's analysis in Tweeten, and it's been used, you use it often, and that is we are being presented with a policy argument. You know, the words intent, policy, purpose appears throughout Bridgestone's brief.
I'm just saying, let's read the language. It seems to me two possible readings.
In this case, what you are reviewing is the decision of the district court, who reviewed this statute for errors of law. Now, leading up to that was a well-reasoned decision from a deputy, affirmed by the work comp commissioner, and, can't remember, I think it was Justice Waterman who asked, that analysis has been confirmed by deputies and commissioners and the district court, and that's Nordstrom versus Karmer. And so the only two cases that are district court level cases that are relevant on this are in favor of Charlie Anderson.
It's the same question that Justice Mansfield asked and see if we can get into the language. Because as you mentioned, it says other than those described. In fact, it goes further. It says other than those described or referred to. There's just no way to read that list of specified, it's like a menu at McDonald's, right? There's the hamburger and the cheeseburger. Well, there's the arm and there's the shoulder. Those are described or referred to on the schedule. So how do we ignore that? If the
Again, I think how we ignore that is and I'm not suggesting it should be ignored. I think it's appropriate to consider. But I think the important part is the legislature picked the language. Now, take a look at subsection I on your list. This relates to any other toe, meaning plural toes. Take a look at subsection S. There, the lexicographer for the legislature talked about both ears. So the concept of plural injuries is in this statute. It's,
I mean, nonetheless, it's not superfluous even under Bridgestone's interpretation, because those are, it's a special formula for those particular multiple injuries, right?
Justice Mansfield, I would say to you that I like the example of a menu or of a list, but if we think of this as a recipe, there's a vast difference in a recipe between 1 teaspoon of salt and 2 teaspoons of salt. And so the legislature, when they wrote this recipe, they picked the compensation scheme, and the district court, which is the matter under review here today, not the Fry case, which was a commissioner-level decision, but the district court's decision, which is under review here today, really gives a great blueprint, and in a sense, that blueprint reflects the Tweeten analysis. And that is, you know, Charlie Anderson, he's a shoulder for sure, but he's also an arm. And I don't have that in my list.
Question about that. The shoulder injury and the arm injury, although the date of occurrence is the same, these were injuries arising out of separate events. Is that correct?
Deemed to have arisen by the deputy, by the commissioner, and by the district court. They were found to have risen from that event, which was, I think it's Halloween, I can't remember the year, but 2018. And so they were not traumatic events. They were deemed to be work-related. And one of the things that's not in the brief factually,
Causes?
the separate cause only from the standpoint that it's the same work leading to both injuries. So Anderson didn't say, I was working with a knife and injured my elbow on that same day. It is that I became symptomatic on this date. Now, not mentioned in
This. So I'm not sure I understand that distinction, but let me give you a different hypothetical. Does it matter if the injuries occur or caused by different events at different times? So if an employee suffered an injury to the shoulder, and let's say filed a claim for benefits, and then 6 months later filed a different petition for an arm injury, those would be compensated separately under M and N. Is that correct?
with you, and that's basically what was decided in Tweeten.
So if that's true, I guess, why does the coincidence of timing here make these compensable in a different way?
Because they arise from one event, and that's your analysis of the district court. I cannot say he was just a shoulder, and I cannot say he was just an arm. And as the court has focused in on, the legislature, it's their statute, it's their language, they're the lexicographer.
That these arise out of the same event. So let's just say the record establishes that the injuries actually arose by different mechanisms, by different events, although they have the same date of occurrence in the findings. So is it mission critical for you that the injuries arise out of one incident or not?
Significant that it arises out of one event. I was just on the verge of saying you were talking about two scheduled member injuries, and again, that's basically what you did in the Tweeten case. And that's on other issues, not the statute of limitations issue. But the one thing that I want to say before my time expires that's important to me, and that is this graphic that you have does not show you an important part about the catch-all. The catch-all consists of 62 words. But in 2017, the legislature actually worked on 30 different statutes in the workers' compensation system, and they specifically unzipped, went inside, and worked on 8534-2T or 2V, the catch-all provision. But what they didn't do, and I give you the graphic in my brief, what they didn't do was touch any symbol in those 652 in those first 62 words, that is the catch-all. Now, what this tells you is there's no mistake here. The legislature was working there. They were doing their craft and adding concepts to subsection V. Those concepts don't alter the meaning of the catch-all, but it's no mistake. It's not an oversight. They used singular. They used a singular A in subsection N when they talked about shoulder. All they had to do was put an S on shoulders and drop the A.
You for a second. So, and I appreciate where you're going with that argument. If it was an injury to a thumb and an injury to a finger on the other hand, does that get us to V?
The danger with analogies is we don't have a fully developed record.
They're separate. It's happened the same day, but it was an injury to two, a hand or a finger on one hand and a thumb on the other hand.
Well,
That's A and B.
I think the answer that you are looking for is that could result in V. In other words, it could go into the catch-all, but that would have to be carefully developed, Justice. That's my only point here.
Under the language then, because you're telling me that if it's M and N, those automatically go into V because V says you only apply M and N if it's one. Isn't that what you're telling me, that A means you only had one injury?
What I'm telling you is I'm not sure until the record is completely adjusted, but a finger and a thumb could roll into the hands. We call it subsumed into the hands, and then that would be T.
Sorry, I understand what you're saying. Assuming it's not, it does not go into the hands. I just want to know if you have an injury to a finger and an injury to a thumb on the other hand, does that get you to V because we have two injuries?
V, Your Honor, in my position is it would get you to V, but when the legislature unzipped it and added those other concepts, it's 265 words, one of the concepts they added is you still have to have a loss of earning capacity. If you return to work, full duty, full pay, full job, you get no industrial disability. That's already accounted for in the
Essentially to the functional impairment under.
basket, but that question was asked on the first argument. And so, to me, this is a case that's heavily shaped by the path of Tweeten or other cases where the court looks carefully at the language. And I like that Young case from 1957 because it says, we sit as a court of law, not as a court of public policy. We interpret the statute that is presented to us, and our job is to hew the line, to guard that line between the work of us as a court of law and policy. We should not add concepts to these statutes or take away concepts to the statutes that the language does not support.
the language is ambiguous. It can be reasonably read in two different ways. Should we default to the reading that favors the employee?
Justice Waterman, what you are referring to is the concept that we construe the act for the benefit of the worker. But it's still a legal analysis that this court, engages in, a matter of law. And so if you find it is ambiguous, then even if you go to the legislative intent, and there's some videos, cited in this record, I don't think they're particularly helpful, but they are helpful on the point that nobody was talking about the catch-all. They were talking about the change they made to a shoulder by adding subsection M, to that statutory list. In conclusion, or at least I'm ready to conclude, I simply want to again state that the decision that is under review here is that of the Polk County District Court. Questions were asked about Nordstrom versus Carmer. It is behind the Anderson case, either on your docket or the Court of Appeals docket, but that case was also decided in the same manner, the same methodology that Charlie Anderson's case was decided. He was a man who he spent 18 months trying to get back to Bridgestone, which is their internal rule. So he sat the bench for 18 months before he had to retire. So it's a little bit out of line to say he voluntarily retired. He was out of time. The clock was up for him, and he does not fit into any provisions other than the catch-all. And the catch-all is there for a man like Charlie Anderson. We thank you for your consideration of this matter.
Stewart, and start with your high school.
I graduated Indianola High School in 2000. So I'm a local gal. All right. I'll be more mindful of the clock this time. Apologies for earlier.
First.
Throw me that number. Thank you. Just briefly, in response to counsel's arguments, I want to refer the court. He's correct that the court is reviewing just the district court opinion, but I think that the original arbitration decision is a good place to look to just get a feel for how this case has been reasoned. And that's difficult to do when you look at the arbitration decision because it really doesn't explain the thought process. It just says, and it's on page 12 of the arbitration decision. The hearing deputy says, she says, in this case, Mr. Anderson did sustain a loss of his arm, but he also sustained a loss of his shoulder. Thus, section N is not appropriate. But I think that's an improper expansion of the statute.
Under Renda, since Renda, we really haven't deferred to the commissioner's interpretation of the workers' compensation statute. We do it de novo, and we won't end up probably deferring to either the district court or the commissioner. We're going to have to figure it out on our own. Isn't that right?
That you should. I only brought that up because I just think it's interesting, just sort of the history of the case and the thought process that's been applied. And I think it's a big leap. And it's happened at the commissioner level and the district court level as well. But it's a leap to go from N doesn't compensate, therefore V does. We do interpret Chapter 85 in favor of the worker, but we can't expand the statute in that process. That's all I have to say. Sorry, Justice.
Someone mentioned the fact that if we go your route and say it's M and N, so that's 40, 40 and 400 and 250. We were talking about, whether or not we should construe this in favor of the employee. Is there a huge difference in the actual dollars that come out if you do M and N together as opposed to V?
Which doctor's functional impairment opinion gets adopted. But the math on the authorized physician, the defendants that performed the surgery, Dr. Davik, he did 8% of the shoulder. The operating doctor on the arm did not assign any impairment to the arm. So 8% by 400, that'd be 16 weeks of permanency. The industrial award that ultimately was made was 50%. 50% of 500 weeks is 250 weeks of permanency. That would encompass, either or both impairment ratings assigned by the physicians of record. Dr. Stoken, the IME doctor, I think did 42% the shoulder and arm, a combination. And I think, I don't know the math on that, but it would be a greater number of weeks. So there'd be, 16 something in the middle if it's just functional and Stoken is adopted, or industrial would result in 250 weeks of benefits.
A fact question I asked Mr. Dutton. What is the cause of the two separate injuries on this record?
Clear. It's a little murky in the record. He claims, and actually the defendant's doctor said the date of injury really didn't reveal a work-related injury necessarily. There is a compensability dispute in this case too. It's briefed, and I didn't want to use the court's time for that today. But that was the day he became symptomatic. That was the significance of the October 31st, 2018. And then he later said, basically, while I'm at it, I want to have my hand numbness addressed too. So my understanding is that he claimed a cumulative process to each individual body part over his time of working at Bridgestone.
Didn't arise out of the other. It wasn't a sequela or nothing.
For separate cumulative injuries attributed to the same date. And well, it can. Cumulative injuries, part of the injury dispute that we have is, or one of the disputed issues before the agency can be what is the appropriate injury date. I know you guys are familiar with that because you just did it in tweeting, but if an injured worker can really pick whatever date they want, and sometimes the employer can dispute that date, but it's basically when they became aware that they had a work-related injury. And so he attributed both of those claimed body parts to the same injury date.
Struggling with if there are two separate injuries with two separate causes, or maybe it's the same cause, repetitive motion or whatever, but they're separate. One's not causing the other, and it seems like they're just combined in this particular petition because of coincidence and timing. Whereas if he had filed two separate petitions 6 months apart, we wouldn't be having this debate. We would know one is M, one is N. So I guess in my mind, I'm trying to figure out, should it matter if it came out of one incident or two, one cause or two, and does that get him across the finish line?
It would be, may I? It would be two totally separate compensations. It'd be very clear that we would use the individual paragraphs if they had two separate dates. In fact, the agency might not even be aware of the other one unless it was brought into evidence for some reason by the parties. But we would just, it'd be very clear. And I think it's interesting that this is the fact pattern that brought this case before the court, because we could have a scenario where there's an acute injury that injures more than one body part, but the facts of this case are that it was two cumulative conditions attributed to the same date. Thank you.
The case of Bridgestone versus Anderson is hereby submitted. The court will just take a brief pause here while we have different attorneys take the table for the next case, which is Lime Lounge versus City of Des Moines.